Most smart home devices are designed to do one thing above everything else. They are designed to wait. They sit on kitchen counters and bedside tables and living room shelves, and they wait, patient, silent, drawing almost no power, generating almost no heat, for the specific sound that tells them to wake up and start listening. When that sound does not come, they record nothing. They store nothing. They consume almost nothing. They are, for all practical purposes, invisible. But there is a second thing these devices do that most people do not think about. A function that runs in the background regardless of whether the device has been activated. A function that the manufacturer describes in page 47 of a terms of service document that almost nobody reads. They back up, automatically, to a cloud account linked to the email address used during setup. Every audio fragment captured during an activation. Every ambient sound clip recorded during a routine diagnostic cycle. Every 17-second buffer the device stores before it determines whether a wake word has been spoken. All of it. Backed up, time-stamped, and stored on a server in a data center that the user has almost certainly forgotten exists. The device sitting on the kitchen counter of Raymond and Carol Ashworth's home in suburban Columbus, Ohio, had been doing exactly this for 2 years and 4 months. It had backed up thousands of audio fragments. Almost all of them were ordinary: a television in another room, a conversation about groceries, the sound of a door closing, almost all of them. On the night of March 7th, at 11:22 in the morning, the device had recorded 17 minutes and 43 seconds of audio that was not ordinary in any sense of the word. It had recorded this audio during a routine diagnostic cycle, not because anyone had spoken its wake word, not because anyone had activated it intentionally, but simply because it was doing what it was designed to do in the background while something that was not ordinary at all was happening 12 feet away in the same room. Raymond Ashworth had been charged with his wife Carol's murder 6 weeks after her death. He had been tried. He had been acquitted. He had walked out of a Columbus courthouse a free man on a Tuesday afternoon in November, having been found not guilty by a jury of 12 people who had heard everything the prosecution could present and determined that it was not enough. 4 days after that acquittal, a 12-year-old boy named Ethan Marsh, the son of Carol Ashworth's closest friend, was sitting at his mother's kitchen table doing homework when he mentioned, without particular emphasis, that he was pretty sure Mr. Ashworth's kitchen speaker would have recorded what happened that night. His mother put down her coffee cup. Subscribe to Sweet Justice right now, because what Ethan said next, and what his mother did with it, is the beginning of one of the most legally complex and morally urgent cases this channel has ever covered. Carol Ashworth had been 41 years old at the time of her death, a high school art teacher, by all accounts warm and generous, the kind of person whose students remembered her specifically and whose colleagues described her in the specific language people use for someone who was genuinely good at caring about other people. She had been married to Raymond for 9 years. They had no children. They lived in a well-kept house in a quiet suburb of Columbus where they had moved 4 years earlier when Raymond's job in commercial insurance had transferred him to the Ohio office. The marriage had not been, in its later years, a happy one. Carol had confided this to her closest friend, a woman named Diane Marsh, in the year before her death. She had described Raymond as controlling and dismissive in private while maintaining a carefully constructed public warmth. She had mentioned, on 2 occasions that Diane would later document carefully in her own memory, that she was afraid of what Raymond might do if she tried to leave. She had not filed for divorce. She had been, Diane believed, trying to find a way out that felt safe. Carol had been found by Raymond on the morning of March 8th, a Saturday, at the bottom of the staircase in their home. Raymond had called 911 at 7:14 in the morning and told the dispatcher that he had come downstairs and found his wife at the base of the stairs, and that she was not responsive. The paramedics who arrived had been unable to revive her. The cause of death, determined by the medical examiner, was blunt force trauma to the head consistent with a fall down a staircase. The manner of death had been listed initially as undetermined, meaning it could not be immediately established whether the fall had been accidental or the result of other causes. The lead detective assigned to the case was a woman named Sandra Howell. She was thorough, experienced, and she did not believe the fall was accidental. She had spoken with Diane Marsh within 48 hours of Carol's death and had received the account of Carol's fears about Raymond. She had examined the staircase and found that the carpet was secure, the lighting was functional, and there was no obvious environmental reason for a healthy 41-year-old woman to fall down a staircase she had used every day for 4 years. She had interviewed Raymond twice. He had been composed both times, cooperative, visibly grieving in the measured way of someone who knows how visible grief is being evaluated, and consistent in his account. His account was this. He had gone to bed at approximately 10:30. Carol had stayed downstairs to grade papers. She did this regularly on Friday evenings, he said, spreading her students' work across the kitchen table and working through it with a cup of tea. He had fallen asleep. He had not heard anything during the night. He had come downstairs at approximately 7 in the morning and found her. Sandra had searched the house. She had taken photographs. She had logged every item of potential evidentiary interest in a search that covered every room of the ground floor and the staircase and the landing. She had photographed the kitchen table, the papers still spread across it, a teacup beside them, and logged the items on it. She had photographed the kitchen counter. She had photographed the small smart home device sitting on the kitchen counter, its ring light dark and dormant in the morning light. She had not checked the device. This was not negligence in any conventional sense. In 2022, the forensic protocol for smart home devices in residential homicide investigations was not yet standardized across most American police departments. Some agencies had developed internal guidelines. Most had not. The question of whether a dormant smart speaker constituted a potential evidence source was one that the field of digital forensics was still actively working through, and Sandra Howell, who was an experienced and careful detective, had simply not been trained to think of it the way a child born into a world where these devices were ordinary furniture would automatically think of it. It had not occurred to her, in the course of a search that was thorough by every standard applicable to residential homicide investigations in 2022, to check whether a dormant smart home device had recorded anything during the night. It had not occurred to the prosecutor's office either. It had not occurred to Raymond's defense team, who would have had reason to check it, and reason to be very glad they had not. It had not occurred to anyone except a 12-year-old boy doing homework 8 months later who had grown up in the specific way that children born after 2010 grow up, with a complete and intuitive understanding of how these devices work that most adults over 40 simply do not have. Subscribe to Sweet Justice right now, because the conversation between Ethan Marsh and his mother on that Tuesday evening is the pivot point of this entire case. And what Diane Marsh did in the 48 hours after it is something that required a specific kind of courage that does not get discussed enough. Diane had listened to her son explain, in the patient and slightly exasperated way that 12-year-olds explain technology to adults, that smart home devices back up audio automatically to cloud accounts, that the backup exists regardless of whether anyone activates the device, and that if Mr. Ashworth had set up the device with an email address, which he almost certainly had because that was how the setup worked, then there was a cloud account somewhere that had been storing audio from that kitchen for as long as the device had been in the house. Diane had sat very still while Ethan explained this. She was a woman who had spent 8 months carrying the specific grief of someone who believes something wrong has happened and cannot prove it, who had sat through a trial and watched an acquittal and driven home afterward and called her daughter and said almost nothing because there was nothing useful to say. She had not cried then. She was not crying now. She was listening to her 12-year-old son explain cloud storage with the focused attention of someone who has just heard something that might matter enormously and is not yet sure how to hold it. She said very carefully, "How long do they keep the recordings?" Ethan had said. "Depends on the plan. Basic plan keeps 30 days. Premium keeps forever." Diane had sat with that for a long moment. Then she had picked up her phone and called the Columbus Police Department's non-emergency line and asked to be connected to Detective Sandra Howell. Sandra Howell had taken the call at 8:47 in the evening. She had listened to what Diane told her. She had been quiet for several seconds. Then she had said, in a tone that Diane would later describe as the tone of someone who has just understood something they should have understood 8 months earlier. "I'm going to need to make some calls." The legal situation that Sandra Howell faced on the morning after Diane's call was one that she had never encountered in 19 years of homicide investigation, and one that, as she quickly discovered, virtually nobody in the Columbus legal community had encountered either. Raymond Ashworth had been acquitted. The Fifth Amendment to the United States Constitution, and Article 1, Section 10 of the Ohio Constitution, prohibited trying a person twice for the same offense. Double jeopardy was not a technicality. It was a foundational protection, deliberately absolute, designed to ensure that the resources of the state could not be used to wear down a defendant through repeated prosecution until a conviction was obtained. It was one of the oldest and most deeply embedded principles in American criminal law, and yet the audio from a cloud account linked to a smart home device might contain evidence of a crime, evidence that had existed at the time of the original investigation and had simply not been found. Evidence whose existence had been known to no one, not the prosecution, not the defense, not the court. Sandra spent 2 days on the phone with the Franklin County Prosecutor's Office, 2 constitutional law professors at Ohio State University, and a digital forensics specialist named Carl Reeves, who had spent 15 years working the intersection of consumer technology and criminal evidence. The question they were all working through was whether the audio from the cloud account could be retrieved, and if it could be retrieved, what could legally be done with it. The retrieval question was resolved within 72 hours. The cloud account existed. It had been set up by Carol Ashworth, not Raymond, using her personal email address during the device's initial setup 2 years before her death. Because Carol was deceased and the account had been set up in her name, access required a court order. The Franklin County Prosecutor's Office filed for the order on a Thursday morning. It was granted by a judge on Friday afternoon on the basis that the account constituted potential evidence in an ongoing investigation, the manner of Carol's death having never been formally reclassified from undetermined. Carl Reeves accessed the cloud account on a Monday morning with Sandra Howell present. The account contained 4,217 audio files spanning 2 years and 3 months. Carl filtered by date. He pulled the files from the night of March 7th. There were 23 files from that evening. The routine backup clips from the device's diagnostic cycles. 22 of them were ordinary, ambient room sounds, a television, the sound of papers moving. The 23rd file was 17 minutes and 43 seconds long. It had been recorded at 11:22 in the evening, nearly an hour before Raymond claimed to have gone to bed, and more than 7 hours before he claimed to have found Carol at the base of the stairs. Carl put on headphones. Sandra stood beside him. He pressed play. "Do not go anywhere. Subscribe to Sweet Justice right now." Because what was on that recording is the detail that changed the legal conversation from whether the audio could be retrieved to something far more urgent and far more difficult. And the path that the Franklin County Prosecutor's Office walked over the following 6 months is one of the most carefully reasoned legal arguments Sweet Justice has ever had the privilege of taking you through. Sandra Howell stood in that room with Carl Reeves and listened to the entire 17 minutes and 43 seconds without speaking. When it finished, she asked Carl to play the last 4 minutes again. He did. She stood with her arms folded and her eyes on the floor and listened a second time. Then she said very quietly, "How did we miss this?" It was not a question. It was the specific statement of a detective who already knows the answer and is simply allowing herself to say it out loud once before she moves to what comes next. The recording captured, with the specific and indifferent clarity of a device that does not understand what it is documenting, a conversation between 2 people in the Ashworth kitchen on the night of March 7th. The voices were identifiable. One was Carol's, one was Raymond's. The conversation lasted approximately 11 minutes before the audio changed in character. The specific change that Sandra Howell, who had spent 19 years working homicide, recognized immediately, and that Carl Reeves documented in his forensic report with precise clinical language that described a sequence of sounds consistent with a physical altercation and a subsequent fall on a hard surface. The remaining 6 minutes and 43 seconds of the recording contained sounds that the forensic audio specialist brought in to assist Carl's analysis described, in her written report, as consistent with movement and then prolonged silence. The conversation itself, the 11 minutes of voices before the audio changed, contained statements made by Raymond Ashworth that the Franklin County Prosecutor's Office determined were directly relevant to the question of Carol's state of mind, Raymond's state of mind, and the events of that evening. The specific content of those statements was filed under seal pending the legal proceedings that followed. What the prosecutor's office had was extraordinary evidence of what had happened in that kitchen. What they did not have, what the double Jeopardy clause appeared to firmly and completely prevent, was any mechanism to use it to prosecute Raymond Ashworth for Carol's murder, unless there was another way. The argument that Assistant Prosecutor Helen Park presented to the Franklin County Court of Common Pleas 6 months after the cloud account was accessed was not a double jeopardy argument. It was, deliberately and precisely, something else entirely. Helen was 38 years old, had been with the Franklin County Prosecutor's Office for 11 years, and had a reputation among her colleagues for the specific quality that the most effective prosecutors develop: the ability to find the argument that exists within the constraints of what the law permits rather than spending energy on the argument she wished the law would allow. She had spent the 6 months since the cloud account was accessed working with constitutional law specialists, digital evidence experts, and a legal theory that had been used successfully in federal court on 2 prior occasions, but had never been tested in an Ohio state court in circumstances like these. She had not slept well in those 6 months. She had also not stopped working. Her argument was this: Raymond Ashworth had been acquitted of the murder of Carol Ashworth. Double jeopardy prevented a second prosecution for that specific charge. But Raymond had also, on the night of March 7th, made a series of recorded statements to Carol, statements captured on the cloud audio, in which he had described, in specific and unambiguous terms, financial arrangements he had made in the months before her death that constituted a separate and independent criminal offense. Specifically, the fraudulent transfer of marital assets to accounts in Raymond's sole name in anticipation of Carol's death. This was not a murder charge. It was a financial crime with a separate elements, a separate evidentiary basis, and a separate charging framework. Double jeopardy did not attach to charges that had never been filed. It was, as the constitutional law professors Helen had consulted acknowledged, a narrow argument. It was not the argument anyone would have chosen if they had had the option of a straightforward murder prosecution. But it was a legally defensible argument, defensible enough, Helen believed, to survive the inevitable constitutional challenge Raymond's defense team would mount. She was right that they would mount it. Raymond had retained a new defense attorney, a Columbus appellate specialist named Gordon Webb, who had built his reputation on constitutional challenges, and Gordon's motion to suppress the cloud audio and dismiss all charges was filed within 2 weeks of the indictment. His argument was direct. The audio had been obtained as a result of an investigation into a crime for which Raymond had already been acquitted. The fruit of the poisonous tree doctrine required its exclusion, and without the audio there was no case. Judge Patricia Monroe heard oral arguments on the suppression motion on a Thursday morning that every constitutional law academic in Ohio had cleared their calendars to watch. The courtroom was full in the specific way that courtrooms are full when the legal question is genuinely unresolved and genuinely important. Not the curious public attending a dramatic trial, but lawyers and professors and law students attending, something that might produce a ruling they would cite for years. Gordon Webb argued for 40 minutes. He was precise, measured, and thorough. He argued that the audio was the product of an investigation triggered by an acquittal, that allowing its use would functionally permit the state to conduct an open-ended post-acquittal investigation in every case where new technology might surface new evidence, and that this was exactly the scenario the double jeopardy clause had been designed to prevent. Helen Park argued for 35 minutes. She was equally precise. She argued that the cloud account had been created by the victim, not the defendant, that its contents had never been within the state's knowledge or control during the original Investigation, that the charges filed were distinct from the acquitted charge in every legally relevant respect, and that the double jeopardy clause protected defendants from prosecutorial overreach, not from the consequences of evidence that had existed all along and had simply been waiting, in a data center, for someone to think to look for it. Judge Monroe took the motion under advisement. She issued her ruling 14 days later in a 31-page written opinion that the Ohio constitutional law community began citing within 48 hours of its publication. She denied the motion to suppress. She denied the motion to dismiss. The audio was admissible. The charges would proceed. The trial lasted 9 days. Helen Park played the 17-minute and 43-second recording in open court on day 3. She played it without introduction, without narration, without any framing beyond the forensic authentication testimony that established its origin and integrity. She let it play from beginning to end in a completely silent courtroom. When it finished, she looked at the jury for a moment and then said quietly, "Nothing further at this time." Raymond Ashworth's defense team did not call him to testify. Gordon Webb's closing argument was a careful and technically impressive restatement of every constitutional objection he had raised throughout the proceedings, framed now as a jury argument, asking the 12 people in the box to consider whether the legal path that had led to this moment was one they were comfortable endorsing with their verdict. The jury deliberated for 11 hours. They sent out one question, asking Judge Monroe whether they were permitted to consider only the financial charges or whether the audio's content bore on the financial charges in a broader sense. Judge Monroe's answer was precise. They were to evaluate the charges before them and the evidence relevant to those charges, and the audio was relevant evidence. They returned a guilty verdict on all counts the following morning. Raymond Ashworth was sentenced to 14 years. The financial fraud charges carried penalties that stacked, produced a sentence that Judge Monroe described at sentencing as reflecting not only the crimes charged, but the full context of the evidence before the court. Diane Marsh attended every day of both proceedings, the original trial and the second. She sat in the same seat each time, in the third row of the gallery behind the prosecution table, with a small photograph of Carol in her wallet that she had carried since the funeral. She did not speak to the press after either verdict. Ethan Marsh, who had been 12 years old when he mentioned the kitchen speaker to his mother over homework, was 14 by the time the second verdict was delivered. He did not attend either trial. His mother had decided, with the specific quiet wisdom of a parent who has seen what this kind of case does to the people closest to it, that the courtroom was not a place for him. She told him the verdict by text message on a Thursday morning while he was at school. He replied with 3 words. He said, "I knew it." Diane read it twice. Then she put her phone face down on the kitchen counter, the same counter where she had been standing 8 months earlier when Ethan had first said what he said, and stood there for a moment in the particular silence of someone who has been carrying something heavy for a very long time, and has just been allowed, finally, to set it down. That is sweet justice at its most technically precise and its most human simultaneously, a device that waited. A child who understood what it had been doing, a prosecutor who found the one argument that the law would allow, and a 17-minute recording that sat in a data center for 8 months, patient and complete, waiting for someone to remember it existed. Subscribe to Sweet Justice for new courtroom stories every day. Share this with someone who needs to hear that evidence does not disappear. It waits. Hit that bell and stay with us. We will see you very soon.